And we are back. Recently, the Federal Trade Commission issued a ban on non-compete agreements. The rule aims to empower employees by restricting employers from enforcing new non-compete agreements, except for senior executives. Now, joining me now to share a little bit more is the founding partner of the Boyd Law Group, Patrick J. Boyd. And as always, Patrick, good to have you with us.
Great to see you again.
So let's break this down. First of all, for somebody that may not be so familiar, when we talk about a non-compete agreement, what are we looking at?
Sure. It's an agreement that the employer will ask an employee to sign, usually when they start, but sometimes even after they've been at the job for a while. And it prohibits those employees from leaving the job and going to, a competitor. Everything from leaving IBM maybe and going to Microsoft, or even as much as leaving Burger King and going to McDonald's or something like that. And the way they're written is quite oppressive in the sense that if you read them as an employee, you might say, geez, I don't know if I can go to another job. I could get sued if I try to go to another job. And in acknowledging that risk and acknowledging the impact on free movement of labor, President Biden passed an executive order quite some time ago, and then the FTC just followed through with it in April, making these non-competes, at least by virtue of its order, unenforceable within 120 days of April, so come to the close of the summer.
Right. So with this non-compete clause, obviously a lot of unhappy people, but let's talk about how this is actually going to play out.
Yeah, well, so it's a great point. I think the order was issued by the FTC in April, and just days later, a grouping of chambers of commerce in Texas filed a lawsuit challenging the authority of the Federal Trade Commission to make the ruling that they made. So it was going to take 120 days to go into effect, and now we've got to have a whole litigation about whether or not it's going to go into effect. The ramifications are still, as a result, quite complicated to figure out. Figuring out what a court's going to do is strange and challenging, particularly with this kind of unique thing. The one thing that we've talked about before on this show, and I would point out, is that some states have already started to limit the enforceability of non-competes, irrespective of a federal trend or a federal piece of legislation to that effect. So I think workers can count on added freedom. This federal mandate may go into effect with some whole or limited impact, but no matter how you slice the bread, there will be more freedom for more workers to leave one job and go to another. We just don't know the extent of that freedom quite yet.
Yeah. And so when we talk about employee mobility, I want to talk about that for a few moments, the potential impact on that. We talked a little bit about it, but let's really unpack this here because, if you work a job, you want to be able to go from place to place, and I think that that's really what employees are saying. Listen, I don't want to have to deal with this, and yet
Right.
still this law really, in some way, shape, or form, helps in that manner.
Yeah, well, you're exactly right, and what you're saying is consistent with the wording that both the FTC and our President Biden put in place when making these efforts. They figure that workers' wages will go up about $500 to $1,000 per year per worker if this law is adopted. They figure that another 8,500 new businesses will be formed if this freedom to move is allowed, and they figure there'll be another somewhere between 17,000 and 29,000 patents a year. New businesses, new ideas, new opportunities, all just by giving these workers more freedom to take a better job without having to worry about being sued for doing so. So a lot of great things that would happen to the economy, at least are seen happening to the economy, to the extent that this law is implemented.
Do you know how they base those statistics? I mean, I'm kind of concerned. I'm not concerned, interested in how they get these numbers.
I certainly don't. I think part of it is looking at comparators between some of the states that on their own have allowed for freedom of workers, that is, that have prohibited non-competes, like California, for example. I think they also take a look at just sort of patent applications and whether or not people maybe choose to use different jurisdictions for filing patents to avoid the non-compete restrictions. And of course, part of it is also a fair amount of speculation.
Yeah.
What I can tell you anecdotally, but I think importantly, is that a lot of workers call us every single week. I would say I get somewhere between 5 and 15 calls from workers saying, hey, I've got a job. I think I've got a better job lined up. I think I have that opportunity, but I have a non-compete. What should I do? So there's lots of workers wanting to make the job move, having to spend money on talking to a lawyer about the job move, or being hesitant to make the job move, all because of these non-competes as the law is currently in place. And hopefully that worry will disappear. They'll be able to say, look, I've worked hard, I interviewed well, I've got a better job, I can just make that job transition by virtue of some of these changes in law, which is a very practical impact for a lot of people.
Yeah. Let's move on to another subject, one that's a little bit closer and near and dear to my heart. Talk about that of college athletes. And now college athletes looking at the perspective of becoming a union, specifically to deal with the NIL and the things that they've got going on. Where do we stand here?
Yeah, it's a fascinating development, and near and dear to my heart too, because the ruling came from a small college up in New Hampshire called Dartmouth, which is where I was lucky enough to go to school. So February 5th, the National Labor Relations Board ruled that the Dartmouth men's basketball team could have a vote to try to unionize, and the players did vote, and by a vote of 13-2, they did elect to have a union representing them. This is something that was contemplated back in 2015 with Northwestern University, but at that point in time, the board didn't rule on it. It had to do with football as opposed to basketball. So right now, the argument is that these athletes are serving the College of Dartmouth. They're providing for revenue for the sports. They're providing for ticket sales and endorsements and all kinds of things. By virtue of that, they're like employees of Dartmouth College, and they should have rights like employees to form a union. Now, just like the ruling or the order rather on the non-compete, this ruling has been challenged by Dartmouth College, so it's going to be adjudicated and argued about for quite some time. But as we sit here today, there is a decent chance that there will be the rights of college athletes to collectively argue for better benefits, certain practice times, certain payments, and those kind of things, and more say in the life that they live as college athletes, not just as revenue generators for the college, but also as revenue generators for their own good and their own well-being.
Yeah. I want to unpack a little bit more the pros and cons of this here, right? Because there are a lot of people saying, listen, college athletes deserve to be paid. They make the institution a lot of money. You talk about you get a scholarship, but the scholarship does not pale in comparison to the dollars that are actually being made by these institutions and universities. But then on the other side, you have those who say, listen, we've done enough. We've got it. It's enough. We've satisfied. They get a scholarship. There's some pros and cons here. But from you, on a legal side, how do you see the pros and cons?
It's complicated, and the law is always informed by the smart policymakers and people like yourself looking at the business and the lives of the athletes, right? I think the challenge is going to be that there is, on the one hand, an argument that the athletes are contributing some dollars in value to the school. But just to take Dartmouth as an example, right? It's a relatively small school with a relatively small impact on revenue generation for the school. And I think that's going to weigh in some ways in favor of the school saying, look, we give a lot to these athletes and they don't bring a lot of dollars to us. There are other schools that are quite frankly very different, right? With athletes, college athletes that are generating a ton of revenue for the schools that they play for, and who argue as a result that they should have more of the benefit of the wealth that they help to create. I think, and you know, I think your insight would be valuable on this, and I've talked to a lot of other former college athletes, but I think that the real challenge is finding some balance between giving some reward to the athletes who obviously make a bigger commitment in their college lives than just a person committing to be a student, right? And who take a risk in doing so, because if they get hurt, they may never play again. And they're playing for the school, not getting paid for it. and risking injury. So I do think there's some value that should be offered to them for it. On the other hand, and I'm sure you've seen this argument too, there's a group of people, including fans, right, who think that there's a lot of appeal to amateur competition. And if you want to play as a pro and get paid as a pro, then go play as a pro and get paid as a pro. And otherwise, enjoy your college experience, but there are downsides to that college experience, including not being paid as much. I mean, the interesting thing that you mentioned, which we're not really talking about too much here, but certainly the two play with, or the two play against one another, is there's also this name, image, and recognition, name, image, and likeness law, the NIL law, which allows athletes to benefit a different way from their sports and their success. And we don't even understand the ramifications of that yet, but that's another way that these athletes who study hard and who compete also athletically can find some way to benefit extra from the extra effort that they make and the extra value that they deliver to the institutions that they attend.
Yeah, if my name's on the back of your school jersey and it just happens to be doing very well, I have a hard time with everybody else but me getting something out of the deal. So I would definitely be calling you and saying I need a lawyer or somebody to have a conversation about this, because we look at name, image, and likeness and the profits and those who have profited, and you turn on the other side, you see these young men and women, and they would go home with nothing at
That's
many
right.
times up until this, and we had something had to be done.
And get in trouble for as much as taking a sandwich that somebody might think of as being, appropriate, or one suit jacket that's misunderstood somewhere.
Right.
So definitely the balance of power, to my view of the situation, is off, right? Whether or not that balance of power is remedied by virtue of the NIL work or the collective rights of the student athletes to organize, or both, I don't know. But it's an important fight to be had for a better balance of fairness. And so I look forward to paying attention to it and talk to you about it as time goes on.
Yeah, I only have a couple minutes left, but I do want to shoot across this topic right here: how public protesting affects an employee's retainment.
Yeah. Right. Yeah. Well, I mean, I think it's an important thing, and as we talk to the younger generation of employees out there, there's lots and lots of them, to their credit, who choose to work for an employer not just because of the pay and benefits of that employer, but also because of the political stances that employer might take, and because of the things that employer might do on a world stage or even a state and local stage. So there's been a fair amount of questions we've gotten from clients who say, I work at XYZ, I work at Starbucks, I work at Google, I work at Microsoft, and I'm not happy with what they're doing politically in this place or that place. And, do I have a right to protest, and what happens if I do? And, the law is unfortunately mostly unclear, but to the extent that it is clear, it mostly operates to the detriment of employees. On the one hand, if you're an employee and you're acting, for example, in New York, not on your workday and on the weekend and in your own private time, and just taking some kind of political activity, you probably should be free to do so. But to the extent that the employer sees you as engaging in some kind of protest that has any detriment on their business, or that is protesting their activities, for the most part, the law says the employer is free to let that employee go. That's a controversial issue, I'm afraid, and people like to believe that they should be able to say exactly what they want once they're gone from work, and it shouldn't have any impact on their work. But the law right now doesn't completely recognize that freedom, and I think that's an important thing that's going to be part of the debates in the future.
So how do we deal with that whole issue? First Amendment rights, employer policy. It's a fine line. I get it. But what can we expect to come down the pike?
Well, the First Amendment rights are a little bit more clearly delineated and better, and that's with respect to the public sector employers, right? So you do have a First Amendment right to express your sentiments when you're working for a government entity and have some kind of protection. In the private sector, though, as we see all the time, and which I think you're alluding to, that freedom is far more limited. And I don't know that that's going to change anytime soon. I just think that it's going to be re-examined and needs to be re-examined because people are starting to think of their jobs as not just ways that they earn a living, but also statements as to their politics and their identities, if you will, which makes sense considering how much time we all spend at our respective jobs. The one other thing I just want to mention in passing, because we got a lot of calls on this too, there's a fair amount of activism, as you know, on the student campuses these days. And we are getting calls from people saying, well, if I'm a student at Columbia, if I'm a student at XYZ, and I'm engaged in a protest, how is this going to impact me? And the one thing I say, and I don't love to say it, but it is true. At this point in time, if you're protesting and somebody's got a snapshot of it on Facebook or whatever, right? That may be something that follows you with your job applications or your future. I don't know that it should. I don't know that it's fair that it does, but it is something that has ramifications, especially with the social media these days where you can capture pictures of people doing anything. And I think it's making the workplace complicated. It's blurring the lines between what we do in our own private time and what our employers know about us doing and what our employers might choose to do to act upon things that, frankly, might not be their business, but they still learn about.
Yeah.
So it's a brave new world.
Yeah, January 6th, I was right there right next to Washington D.C. Stayed in a hotel, rode up on 95 coming back this way, and saw many cars that were really engaging in protest and a couple of other things. But the long story
Yeah,
short was that even though they weren't the ones who stormed the Capitol, many people who were actually in cars and showing up in protest form had to answer to employers simply
that's right.
because their picture was associated with the January 6th insurrection attack. And so there's a lot to be said for how your personal impacts your professional, and it's something that's going to be debated, and we'll definitely need some courts to hash this one out for some
Yeah.
time to come. Yeah.
Yeah, yeah,
So
it's an interesting time. There's just so many more. I mean, I think the great news is that people are active in thinking about their jobs and their lives, and active in politics. I mean, but I think the alarming part is that the go home and live your own life concept just doesn't exist the same way in this world of social media, and that's something that's not going to change. We can't put the genie back in the bottle there. So there's a lot of law that needs to be contemplated along those lines.
yeah, it's a lot to unpack. And Patrick Boyd, my friend, it's always great having you on because we have some good conversation, good dialogue, and some great explanations. So I got to have you back soon. So thanks for joining us.